So as I was saying, we know as employers, our friend is the internet, right? So these are really the current statistics, and they change all the time, about employers' use of social media. So we all know that we as employers, and our position has always been, if an employee or potential employee wants to post all kinds of information publicly on the internet, we're happy to look at that, right? And we'll talk a little later about, just because something is posted publicly on the internet, what you can and can't do with it. But these are sort of the current statistics about employers' use of the internet and social media and other websites to, see what their employees are doing, check out potential prospective employees, that kind of thing. So we're going to talk today, we're going to start out with a private employer discussion about everything from what you can do using the internet and social media sites with respect to hiring, firing, disciplinary issues, and there is starting to be really a growing body of case law out there about what employers can and cannot do in those areas with respect to use of information that's publicly or even sometimes privately posted on the internet. Because one thing that we do know, frankly, as employers is, even if we don't as employers look at our employees or prospective employees' social media sites or public internet postings, you can almost guarantee that their co-employees are, right? And so many times, if there's some issue with some sort of posting on the internet, it's not the employer really that is monitoring that or finds it out, but more likely it's that a co-employee, co-worker, or even sometimes clients and members of the public have brought it to the attention of the employer that there's something out there that we need to take a look at. So let's start out with leaves and work-related injuries. I always tell everyone, employees, if you're going to tell your employer that you're sick and you can't come to work, maybe you shouldn't post pictures of yourself whitewater rafting in West Virginia during the day that you're supposed to be out sick. That's actually a real case that I handled. But we see this stuff all the time. So there's been a real blurring of the lines between, what is work-related communication, what is communication in which employees are engaging on the internet that can be used with respect to their work and with respect to their leaves. And there's now a growing, as I said, a body of case law out there about that very topic. So if we go on to personal versus work-related, as I said, we've had a real rash recently. I think it's probably because there's so much political communication going on and so much political discord within this past year with a hotly contested presidential election. We've seen a lot of clients really talking to employers about what their employees are doing and saying on the internet. So this just keeps snowballing and snowballing with respect to employers being put on notice of issues involving their employees' use of social media and of the internet. One of the areas that we see a lot of activity in is employees that have, for instance, filed lawsuits against their employers. We could go on to the next case. There are a lot of cases out there that talk about this. So if you have an employee that claims to have been sexually harassed, if you have an employee who claims to have been injured in the workplace, or is claiming some kind of damages or harm from the workplace, and they file a lawsuit over those issues, many courts are now saying that you as the employer can have access to even the private portions of your former or even current employees' social media sites for purposes of gathering information related to the claims made in their lawsuit. For instance, this is a case out of Indiana. This was a plaintiff, an employee who filed a lawsuit alleging that she had been sexually harassed and was being subjected and had ongoing emotional distress. So the court ordered production of materials from that person's Facebook site that were relevant to those issues. You know, what other things are going on in her life related to emotional distress, those types of things. So, you know, we used to, 20 years ago, hire private investigators, right, to go out and take a look at what our employees are doing if they filed lawsuits against us, to see, you know, maybe they claim they're injured. So we we hire a private investigator to go out and keep an eye on them to see whether they're, you know, putting a new roof on their house. Well, employees have made it a lot easier for us now. We don't actually have to hire people to follow them around. They just post everything on the internet, and we just jump on the internet and find out what they're doing that way. So there are other cases that we've highlighted here, and these fall under all kinds of things. You know, if you are filing a lawsuit and you're claiming certain types of stress and damages and that kind of thing, you better be ready that your employer or the person you're suing is going to ask the court to allow access to even the private portions of your social media sites to uncover information that may be relevant to the lawsuit. Here's another case that this was an insurance case. It was a suit claiming that there needed to be insurance for children and the insured who had eating disorders. And as part of that, the court ordered that the plaintiffs turn over the children's writings from their social media sites to see if that information was relevant to the issues presented in the lawsuit. So those are the types of things that we are seeing, and Stacy's going to take the next case as well from the Texas Court of Appeals.
Thanks. So we have Edinburgh Schools versus Esparza, which just came out of the Texas Court of Appeals in 2020. In this case, we have a school principal who took a picture of herself, a nude photo of herself, on her cell phone, and then it's alleged that that was distributed not by her, but by a third party that somehow got a hold of that and sent it out. Of course, something like that quickly caused quite a stir with the school. And so this ended up resulting in a lawsuit because she was terminated for that, violating school policy. And the district court ruled that the release of the photo, whether voluntary or not, violated the employer's policies. And they quoted, and quote them here, "The fact remains that a voluntary taken photograph originally taken by Ms. Esparza has entered the public domain and has become an object of great controversy in the school community." The policy itself provided that if an employee's use of electronic media interferes with the employee's ability to effectively perform his or her job duties, the employee is subject to disciplinary action up to and including termination of employment. There was also a note in the district court's finding that the electronic media policy in this case actually defined electronic media to include all forms of telecommunication, landlines, cell phones, and web-based communications. Of course, this got appealed up to the Texas Court of Appeals, which is where we have this today. The photo's dissemination amongst the students in the community interfered with the principal's future ability to effectively perform her job duties so as to constitute good cause to terminate her contract. It was reasonable for the school board to infer from the escalating media coverage and the fact that the photo had recently gone viral that the disruption and distraction from the photo would continue to interfere with her ability to effectively perform her job duties in violation of the policy.
Stacy, could I jump in for a second?
Please do.
There's a couple of things I think that are important here. It was actually the fact that she took the nude photograph of herself that the court ultimately relied on to uphold her discharge. Because she took it, essentially the court said that that in and of itself violated the policy, and the fact that it was then distributed without her permission didn't take away from the fact that she had violated the policy to begin with. I think the same result would have happened if she had allowed another person to take a nude photograph of herself, and then that person again distributed the photo. I think she still would have been subject to termination. The only way I think it would have been different is if a third party had taken a nude photograph of her without her knowledge and then had distributed it, then I think there would have been a different result here.
No, I think that, thank you. That is a really important distinction, especially when we have all kinds of concerns with data integrity these days, and we walk around with cell phones that are recording all kinds of things, whether we know it or not. So those are some important distinctions, and where the voluntary part comes in. So the next topic we have here is hiring and interviews. While some of you all may be very used to conducting interviews, over the internet, over the phone, previously, we know a lot of people have adapted that maybe didn't do that and did everything in person. So maybe this is bringing up an opportunity for your hiring panels to do a little more searching on candidates, just because you're in a different environment now. So we wanted to bring up some things to think about in the process of hiring and interviewing. Of course, we have a note there, nothing is ever really deleted. So whether we're talking about that previous case that we just talked about, or other things, we hopefully haven't had personal experiences, but we all see things all the time where someone thought something was deleted and it wasn't. So we have Facebook profile pages. We know there's a million other types of social media platforms out there that contain quite a bit of information about people, whether it's LinkedIn or whether it's personal social networking sites that are available out there. Every day seems like there's a new one. TikTok, which is primarily video, but you can learn something about someone, seeing what kind of dance moves they're showing off on TikTok or what types of things they're commenting on. So again, Facebook in particular provides an easy one to talk about in our context, and one that I think all of us generationally are pretty familiar with. There's certainly information that is a great opportunity to go in and see a little bit more about this candidate before you're talking to them for the first time. Things about their education and employment history, maybe videos and photos about the things they do outside a job, maybe videos and photos about what they do at their last job, friends lists, who they associate with, their status updates, how often they post about things, how often they're posting on things like Twitter, other platforms as well. Facebook, again, gives us some real-time communications. Twitter does as well, and how they react to people, whether public or friends commenting. And then, of course, contacting residential information. Where have they been? Where are they living now? Do they appear to be someone local? Does that matter for your position? Maybe it doesn't. Of course, we still need to keep in mind all the things that would be off limits in an in-person interview, or regardless of on the phone or anything else. But during that interview process, these social media platforms may give you some access to information that your interviewers need to be careful about how that comes up during the interview process. So things like marital status and information regarding children, religious information, of course, political views, which, in our current environment, seems like the whole last 4 years, but, politically, there's a lot more people commenting, I feel like, at least out of my family and friends, that are commenting politically that I would not have expected to on public forums. So while you can take a look at that stuff, you have to be really careful about how it comes up later during the interview. Of course, age, and potentially even medical information. There might be stuff on there about something they've been through recently, COVID related or anything else, but medically related information is, of course, sensitive, and union and political affiliations. So, of course, it's not per se illegal for employers to access that information, especially, public information, especially on social media sites. But as I said at the beginning here, we have to keep in mind on how that's used during the interview process and the application process, and how that information is used in evaluating that candidate. If employers are, in fact, a lot of data out there is showing that employers are rejecting job applicants when they find references to things like drug use, drinking, sexually offensive materials, violent imagery, or anything else that's going to reflect poorly on that applicant that's out there publicly that they've contributed to. Of course, again, the political statements, that can't be understated right now, about how that is out there. And again, people may just flat out reject applicants that way. Of course, we have to be careful about how that information then goes into evaluating the applicants, and how that's reported. Of course, we have cautions to our employers. More than 20 states, including Michigan, have put laws on the books that forbid employers or potential employers from asking certain questions, and is specifically asking employees or applicants to grant access or allow observation of or disclose information that allows access to personal internet accounts. In Michigan, that's our MCL 37721. Of course, that does not prohibit an employer from using voluntarily disclosed information not covered by these statutes. I come from a world of higher education. For quite a while there, when social media was really hitting big, schools were asking athletes to give over that information, and of course the laws or the state stepped in and on a lot of places and started to shut that down, saying we can't force employees or students or other to give that information up.
So let me jump in here, and I want to do just a housekeeping for a minute. I want to make sure that we've got plenty of time for the public employer section that's going to be presented by Mike Bogren. I'm just going to sort of hit a few highlights in the next couple of minutes, and then we're going to kick it over to make sure we have plenty of time for Mike to present. But a couple of things to keep in mind. I get calls all the time from employers. Just because you found something out on the internet doesn't mean you can use it, okay? So this comes up a lot in the hiring context. You know, if you can't ask a particular question of an employee that's interviewing with you, that's sitting with you in your office, you know, you can't ask them if they're married, you can't ask them how old they are, those types of things. You can't ask them if they have a disability. If you can't ask those questions in an interview, you cannot use that information if you find it out in some other fashion, if you find it on the internet. If you see stories on a Facebook page about someone has been sick with some sort of illness, I get calls all the time from people saying, yeah, we saw on their Facebook page that they have cancer, for instance. Do we have to hire them if they're otherwise qualified, and we would hire them anyway? The answer is you cannot use that information to make decisions that was found just because it was found on the internet if you couldn't ask it in an interview. Also, you know, be careful about how you're doing investigations. I mean, you have to have some pretty good information before you start suspending people and terminating people based upon their internet usage. So, you know, keep your eye open for, you know, good information. Like I said, it usually comes from other people. It comes from clients. It comes from co-employees. And you can use this information for termination and discipline. We've included quite a few cases here. We're not going to go over those cases today, but they're in your materials. Just some examples about types of information that have been used, that have been allowed by courts, and that have not been allowed by courts. And last, I just want to say one thing about us employment lawyers' favorite topic, which is sexual harassment over social media. So remember how it used to be, right? So you'd all go out to happy hour with your coworkers after work, and you'd have a glass of wine or a beer, and then you'd all go home and see each other the next morning. Well, now what happens is you go out to happy hour with your coworkers, and you have a glass of wine or a beer or two, and then you go home, and then you start chatting with your coworkers after you've had a glass of wine or a beer or two on social media. And now all of a sudden your inhibitions have been lowered because you've had some alcohol, and you start saying things that aren't particularly appropriate to your coworkers that you never would dream of saying to them if you weren't texting them or on social media. And now all of a sudden, even if you're not in the workplace, we can still have sexual harassment claims based upon your off-duty conduct with your coworkers. So we have seen these claims. We have seen these claims rising. You as employers need to understand that if you have an employee that comes and complains to you about being sexually harassed by a coworker, and that harassment has taken place over social media or texting or something outside of the office, you can't just say, sorry, that didn't happen at work, we're not going to do anything about it. You still have a legal responsibility to take reasonable action to make sure that that sexual harassment or other inappropriate conduct doesn't continue. So Stacy, I'm going to have you fast forward onto our public employment issues and turn it over to Mike Bogren.
Thanks, Christina. Let me start out by addressing what seems to be a common misconception, frankly. You know, we've seen it in a number of contexts, and maybe most significantly in the last few years over the whole thing about the protests before NFL games about players kneeling for the national anthem. And you hear a lot, well, they have a First Amendment right to protest. Well, they do, but the First Amendment only applies to the government. The First Amendment does not apply to any private employer as employer. So while we all have a First Amendment right to protest without governmental interference, we don't have a First Amendment right to protest or to speak without having repercussions from our private sector employer. Now, that's not to say that there can't be protections, because there are a number of both state and federal statutes that do offer protection to private sector employees, including Title VII, the FMLA, the ADA. There's a number of state laws, including Michigan's, which protects a much greater group of individual classes than federal law do. And all of these statutes also have anti-retaliation provisions. So I don't want to suggest that private sector employees have no protection, but what they don't have is First Amendment protection. So with that said, I want to talk about public employers and employees and the application of the First Amendment. In 1968, the Supreme Court decided Pickering versus Board of Education. And prior to that point, public employers were pretty much given carte blanche to do what they wanted to when it came to their employees and restricting their speech and controlling their speech while they were in their employment setting. Pickering changed that and said that when an employee takes public employment, they do not surrender their constitutional rights. And since their employer is the government, they still have First Amendment rights. What the court did then is created a distinction between commentary on a matter of public interest and commentary on what they termed purely personal or internal issues. And in Pickering itself, it was a teacher who complained that the Board of Education was spending too much of the district's resources on athletics and not enough on education, which he believed was the primary function of a school district. The district fired him for his comments, and he sued, and the Supreme Court agreed that he did have First Amendment protection because the expenditure of the school district's resources was a matter vital to informed decision-making among the electorate, number one. And then number two, they established a balancing test which weighed the employees' First Amendment rights to free speech on the one hand versus the employer's need to have a well-functioning workplace. And the court did recognize the significance of government employment in the sense that the government provides services to everyone. And in order to provide those services, they have to provide essentially a well-oiled machine, if you will, a workforce that is efficient and productive and can accomplish its task. So the court said that there has to be a balance between a person's right to speak on the one hand and the employer's need to have an efficient workforce on the other hand. In the Pickering case, the court said that the balance favored Mr. Pickering because he was not complaining about teachers that he taught with. He was not complaining about the administrators in his chain of command. He wasn't complaining about his building superintendent, for example. He was complaining about the Board of Education making policy decisions. And they said under those circumstances, the balance favored Mr. Pickering. So that was really the start of more protection for government employees than had ever been in place before. The Conic case, which was decided in 1983, sort of piggybacked on Pickering and put some meat on the bones, if you will. And there, an assistant district attorney in Louisiana, and just as an aside, Mr. Conic gets sued on a fairly regular basis. By all accounts, he was very good. He's no longer in office, but he held the office for something like 40 years. And just as an aside, that's Harry Conic's father. But he fired Ms. Myers because she was dissatisfied with the way things were going in the district attorney's office, and she created her own internal questionnaire that she's distributed to the other assistant district attorneys and basically asked how they thought things were going, with the idea that she wanted them to respond that things weren't going well and that they shared the same criticisms that she had. So he fired her. She filed a lawsuit claiming a First Amendment violation, and ultimately the Supreme Court sided with the district attorney and said that although there were some elements of issues of public concern, that really what this came down to was a disgruntled employee who was looking for more ammunition in the next round of disputes with her employer. And the court said that because of the nature of the work that the district attorney's office does and the need for cooperation among the district attorneys and between the district attorney and the executive attorneys that essentially were responsible for running the office, that they needed people to, sort of be on board with the program. And if you weren't and you were disgruntled and you were expressing your dissatisfaction, that was an appropriate basis for a discharge. So the Pickering Conic test is what has come out of these two cases. And it asks two questions. One, is the employee speaking on a matter of public concern, which the court has defined as a matter of community significance? Or conversely, is this a personal grievance or an internal dispute that really does not have significant implications for the community at large? Assuming that it's found to be a matter of public concern, then the court employs a balancing test and weighs the rights of free speech against the government's interest in an efficient and productive workforce. Many times the results of that is going to be dependent on the nature of the work that the employee is doing. For example, the courts give great deference to public safety, police, fire, ambulance services, because they characterize those as being very stressful jobs and requiring the most cooperation among employees and between employers and management. And therefore, people that challenge management or that are disgruntled and create controversy are going to be the most disruptive. And in those sorts of settings, the courts are going to be the most deferential to the employer, and the balancing test typically is going to favor the employer. On the other hand, if you're in a setting, like an office setting, the assessor's office, for example, there's going to be more leeway given to the employee in those circumstances. So, for example, if an employee complains about the manner in which the assessor is making her assessments, that's going to be given, more deference to the employee rather than to the employer. So it's really specific about what job duties are being performed and what the function of the department that's involved will be. Garcetti changed the analysis pretty significantly, because in Garcetti, it was an assistant district attorney in Los Angeles who made an internal complaint to his direct supervisor and ultimately to Mr. Garcetti, who at the time was the elected district attorney, who's now the mayor of Los Angeles. But Mr. Ceballos complained that the search warrant affidavit that was used to secure, I'm sorry, the arrest warrant affidavit that was used to secure the arrest warrant contained misrepresentations by the police that filled it out. And, you know, he said that that's inappropriate, that needs to be addressed. I'm not going to work with these officers any longer, I mean, things of that nature. And he was terminated. And he filed a lawsuit and said, well, no, this is clearly a matter of public concern. And the Supreme Court said, even if it is a matter of public concern, if the employee is speaking as part of his or her official job responsibilities, they lose First Amendment protection. So because in that case, Mr. Ceballos had an obligation to comment on arrest warrants and arrest warrant affidavits, the fact that he was raising a fairly significant issue of wrongdoing did not provide him with First Amendment protection. So, you know, that I think is a significant change in the law, and one that has really favored the governmental employer over the years. We've got, I'm going to skip over the political candidates. The bottom line on political candidates is unless you're someone who is directly responsible in a position of authority, you can't be fired because you're in the wrong political party. The exceptions are the governor can have Democrats in her cabinet, can fire Republicans that were in the previous cabinet, because those are positions of trust and responsibility, and she needs people that will execute her policy. So that's the exception. Let me skip ahead to the last two cases that we've cited. I think they're significant in today in the issues that we're all facing, in particular employers. They both have to do with social media. Marquardt, and they're both out of the Sixth Circuit. Marquardt involved a captain in Cleveland EMS who ostensibly made comments about the shooting of Tamir Rice. He claims that somebody took his phone and made the comments. They weren't really his. The court didn't really get into that, but even though he made some extraordinarily disturbing comments, the court said that they were still comments on a matter of public concern, because there was such a huge amount of discussion and dispute, frankly, about whether the police were justified in shooting this young man. So even though, again, he made some outrageous comments on his private social media site, and even though he made clear that he was commenting personally and not as a member of the department, the court found that he was speaking on a matter of public concern, and therefore reinstated his lawsuit, but sent it back for the court to do the balancing test. The case sort of in contrast to that is the Bennett case. And in Bennett, it was an EMS employee, or I'm sorry, essentially a 911 employee, who posted a comment on the night of the 2016 presidential election. Again, an offensive comment, but she was using language that another poster had made criticizing the election of President Trump. She was defending it and essentially repeated that language back. A number of people complained, and she was terminated. And there the court upheld the termination and said that because of the need for the EMS operators to work cooperatively and the need for management and the employees to work together, her racially charged and divisive statements created such an amount of animosity and discord that the discharge was valid. In contrast, the Marquardt case made a comment to the effect of, you know, the comments, even though they were personal and expressed one person's opinion, the matter in dispute or the matter being discussed was of such import that the employee was entitled at least to get to the balancing test. I'm not sure that the two results can be reconciled, other than the fact that it demonstrates a pretty clear distinction between the judges that decided the case, and I hate to be cynical, but that really is the distinction. That and I think that just reflects what we see throughout society, that there is a really significant divide, and it exists in the courts just as it exists among employees and among employers. So I think it's going to be interesting to see how this develops. But the bottom line here is that if you're an employee, you better be careful about what you post on social media, because it more and more frequently is going to be used as a basis for discipline up to and including discharge.
Well, yes, and those two cases, Mike, are really instructive to our audience, because that just goes to show you that there really are no hard and fast rules when it comes to, I mean, I get calls from people and they tell me about the most offensive comments and posts by their employees. And if you're a public employer, you have to be very careful about any sort of knee-jerk reaction to those types of postings, because just like you demonstrated with those last two cases, it really can go either way sometimes. So that's just a good final message to all of our public employers out there. We're nearing the end of our session. I think we're getting real close to going back to our breakout room is going to close in 56 seconds. So if anybody has
right back over there.
If anybody has a super quick question, we could maybe entertain a quick one, but.
And also our emails are up on the screen, so jot it down quick if you want to email us a specific question. We unfortunately didn't have a whole lot of time here. There is nothing in the chat at this moment.